He's going to talk a little bit about domestic violence right here in Pierce County. So if everyone wants to find their seats, I'll hand it over to Craig.
Good morning and welcome to Pierce County. In case you didn't know, we're #1. We have the highest rate of domestic violence in the state. We also lead the state in the issuance of protection orders. What I can tell you is that we do a pretty good job of providing services to victims. We have wonderful agencies. We've got the YWCA, and I see they're well represented here. They do an awesome job. If I do say so myself, Family Justice Center does an awesome job, and all the other providers throughout the county. One thing we're lacking is holding batterers accountable, and I'm so glad for today. This is one way, the surrender of weapons is one way of holding batterers accountable, and I hope we can get our act together and put together a program like you have in King County. So I just want to say thank you to everyone who made today possible. I'm going to sit down now so that we can learn more about firearms surrender and less about me. So thank you.
Okay, we're going to bring our panel up. Panel members, please come on up. Okay, so we are going to start again with Ms. Kim Wyatt, who is going to tell us more about the Regional Domestic Violence Firearms Enforcement Unit, aka the unit, aka RDVFEU. So Kim, I will hand it over, and we have a request to try to hold the microphone quite close to our mouth as we speak. Thank you.
Yes, I historically have issues with microphones, including at the Senate testimony. Hopefully they edited some of that out, but I had some trouble there. Well, once again, I'm Kim Wyatt. I'm a prosecutor with King County and part of the Regional Domestic Violence Firearms Enforcement Unit, the most difficult name, I think, to say. But I have the privilege of being one of the firearms prosecutors on this team. And I would just want to briefly pass it down so each person can introduce themselves. And just real briefly, obviously I work closely with law enforcement on extreme risk protection orders, and also with law enforcement and detectives, or law enforcement, on all order to surrender weapons cases, meaning when we're trying to enforce court orders to get firearms. And I've been a domestic violence prosecutor. I've been a prosecutor since 2001, but a domestic violence prosecutor for the last 11 years.
My name is Divina, Agbisit, and I am the court orders problem solver for the Regional Domestic Violence Firearm Enforcement Unit. One of my main jobs is working with law enforcement as a first point of contact and an immediate contact when there's any issues with orders being illegible, scrivener's errors, they didn't get all the pages, they're missing a secondary page or order, missing the OTSW. So I work with them hand in hand and try and get those orders so that they can be served, entered into WASIP, and executed as soon as possible.
I'm Theresa Phillips. I'm one of the domestic violence firearms coordinators with the Regional Domestic Violence Firearms Enforcement Unit. I tried to get everybody to shorten it to just DV&F, but
Hi, I'm Stankovich. I'm a detective with South Police Department, DV, Order Service, and Firearms Recovery Unit. We're a pretty small unit, made up of 4 detectives and 1 sergeant, and basically we serve court orders. Serve all sorts of court orders. Anywhere from orders to surrender weapons, DV, protection orders, stalking, FAPOs, SAPOs, anti-harassment orders, some ERPOs, and we go out, serve those orders, and collect firearms.
Good morning. My name is Lorinda Tsai, and I'm a firearm enforcement advocate for here is a firearm surrender advocate. So I guess my title changing all the time, daily. So I am sometimes referenced as the herbal advocate or civil protection order advocate. So I work with order to surrender weapons in all types of civil protection orders within the unit. I would not even attempt to even say the full name of our unit because I would get it all messed up.
And I forgot to mention, there is going to be a portion at the end for questions and answers. You should have an index card in your folder if you would like to write down a question as you think of it. And Logan, hi Logan. Logan will be happy to go around periodically and collect any questions for you, and we'll look through them and make sure that we address them at the end of the session. So back to Kim.
Okay, so just real briefly, just wanted to give you an overview. You heard Chris and David talk about all the long meetings that they had for several years trying to get our unit together. And our unit did officially begin on January 1st of 2018, and you can see above what it entails. We have, along with myself, there's 2 other firearms prosecutors on our team, a court coordinator, court order problem solvers, and you've heard from our detectives. We have a paralegal, of course our fabulous advocates, and we have a law enforcement data technician with the Sheriff's Department, and her role is to help assist us with running firearm purchase history and CPL info, and then also our program manager who can be here today, and then of course Chris and David who you heard from earlier. So it sounds like a lot of people I know. We do have tips for folks who can't have a unit and don't have funding, so just put that out there. So, as we've all been talking about risk, the goals of our unit obviously are to prevent future firearm violence. And so we do that. We believe our model is effective in reducing both homicide, suicide, officer fatalities, and of course, mass shootings. So that's our work. It's heavy work, but very purposeful. So with that, we'll get into our panel.
Okay, we are going to start with Lorinda today. And Lorinda, if you can talk about what types of cases have orders to surrender weapons?
Yes, as I mentioned earlier, before I come into this unit, I work as a protection order advocate, and I'm usually based in Kent. And I worked within that protection order unit for 10 years. So my main focus at that time is mainly domestic violence protection order. But since joining this unit, I have learned the various other type of civil order for protection, and that has an order to surrender weapons. And so that includes anti-harassment protection order, sexual assault protection order, stalking protection order, restraining orders, and then now I think with the new law that passed, have the petition for initial involuntary detention of a family member. So that is something new, and also sometimes with also criminal protection, criminal no contact order that could be either a felony or a misdemeanor. NCO as well, and sometimes those NCO that coming from cases that could be harassment case, sexual assault case, and court initiate SAPO felony NCO. And extra risk protection order as well that I work with family. Kim mentioned earlier this morning that I did assist 2 family. Last year, one is a brother and sister, and then the other one is a dating relationship. And then, so those are very unique, and I learned a lot actually working on the ERPOs in those 2 relationships, from seeing it from a different perspective. Interestingly, is that all the civil order for protection, there is one civil order for protection that is called vulnerable adult protection order. That's the only one that do not have an order to surrender a weapon, and we don't know why. It could be a legislative oversight or things like that. So that's the other part of that part. And so, order to surrender weapon can be issued at 2 different stages: at the ex parte stage, or at the final order for the final protection order hearing. either the anti-harassment or SAPO or the final hearing. So those orders to surrender weapons come during those time frames.
Can you tell us what a vulnerable adult is?
So vulnerable protection order under that is, I think it's defined as anyone who has a disability that's disregard of age, or anyone who is 65 and over and also has some physical limitation. And someone can file as a vulnerable adult petition when that person is being physically threatened, physically harmed, verbal abuse, all of that. And what the other component on the vulnerable adult protection order, it also addressed the financial aspect of abuse. That's the only protection order that addressed that. Every other civil protection order do not address the financial piece of what the petitioner is going through.
And tell us how you get your cases.
So in King County, we have 2 different courthouses. One is called the King County Courthouse, and one is the Regional Justice Center down in Kent. And we use the I-90 as a dividing line where the case destination is. So you will see sometime civil order for protection has a SEA case destination or a KMT case destination. How we get our cases is through many different channels. It can come through the advocates that is based at the King County Courthouse or at the RJC in the the Protection Order Advocacy Program. Or sometimes we got those cases, now we are able to work with the Department of Judicial Administration to give us a list of petition for order of protection that was filed the day before, so that we can get those cases the next day within 24 hours or 48 hours, so that we can follow through. Sometimes we also get cases from referral from community-based advocate, felony case advocate, or misdemeanor case advocate. So those are the cases that come to us. And then we do follow up. So I'm in charge of all the South End, which is the KMT case destination, and all the filing that is from South End. Theresa and Sabbath is not here today. She is Theresa's job share partner, and they are the coordinator. They usually are handling the SBA case and all the City of Seattle case. So that's how we got our cases through the court system or the community.
And when you receive a case, do you have to follow up with it, or do you have discretion on which ones to take?
So when we get a case, in King County last year in 2018, there are a total of about 1,100 cases where an order for protection is granted along with an order to surrender weapon. All of those cases are being reviewed by both myself, Theresa, and Sabbath based on that. Every single order that has an order to surrender weapon are all reviewed. Based on those cases, we are looking for firearm positive or firearm negative, which we'll get into that a little bit later. The firearm negative, we look at those and then sometimes we set that aside because those, it's not that they are not important, it's just that we need to focus our energy on the firearm positive one. And every one of those cases, we also run their consumer license history, their purchase history, and then we also kind of like check the database for any history where they are prohibited from having access or possession of weapons. So we all look at those cases and we do a lot of investigation on those. And then so every single cases that has an order to surrender weapon is reviewed for the King County Superior Court. We sometimes are contacted by the district court as well. So I have been going to district court cases for protection order as well sometimes. And then I go to those as well when it's requested.
Thanks, Lorinda. Let's move on to Theresa. Theresa, can you tell me some of the questions that you ask petitioners to help enforce the order to surrender weapons?
Is it okay if I sit? If I just hold the microphone close? Okay. So, as Lorinda explained, we've got these staff positions where we're advocates, and what we're doing is we're looking at all of the domestic violence and stalking and sexual assault protection orders that are filed in King County, and we're trying to determine if there's a component of firearms in the petition. So we're looking through the actual filed petition to see if there's any information, not just in the one particular section of the checkbox, does the person, respondent, own or possess firearms, but we're looking through the narratives, we're looking through the declarations that are filed, and we're just trying to determine, are there concerns that this person has that the respondent may or may not have firearms or be looking to purchase one. And then we're kind of the next step, once we determine that a case is firearm positive, so there's a concern about firearms and the person is going to be served with an order to surrender weapon, we reach out to the petitioner in the case, who's usually the domestic violence victim or sexual assault or stalking victim, and we try to gather some information. The idea is immediacy and trying to do that up front as best as possible before it's sent to law enforcement for service, so that we can communicate as much information as possible to law enforcement, so that as they're going out, they have really specific information about the firearms that they can then talk with the respondent about. Let's see. You guys all have in your packet a firearm interview worksheet in your orange packet, and then there's also firearm identification worksheet with pictures of guns on the back. So these are some questions that we ask petitioners when we reach out to them. I'm just going to kind of go back and warn you all that I have a particular soapbox that you'll hear me come back around to every time I speak about this, and that is that in any firearms unit or any follow-up information that you're reaching out to survivors about firearms, advocates need to be at the table, and these sorts of things need to be done with advocates, ideally as the ones asking the questions. And I really am passionate about that because I think that advocates have a particular awareness as to, and training as to what survivors are needing to hear at that time. So one of the first things when we're reaching out and talking about firearms with survivors, whether it's on a criminal case or a civil case, is that we have to talk with them about confidentiality, that we don't have confidentiality, that we're working within the system, that we're sharing their information that they're providing to us with law enforcement, prosecutors, eventually the court. And for some, as many of you well know, for some survivors, that's not safe for them to share that kind of information and be the source of telling somebody in the system about their partner's firearms. And so we kind of, and that's why I think it's so important to have advocates doing this, because we know how to have those discussions, how to refer people appropriately when they're not able to safely talk to somebody in the system about it. Anyway, so these are some of the questions, these are just examples, some of the questions that we ask folks. And I'll just say that any advocate can ask these questions. It doesn't have to be a firearms advocate or a firearms coordinator. I think that we sort of developed this list over time. It started out with just a few questions, and then as we were sort of passing information to law enforcement and prosecutors, we sort of realized, oh gosh, there's some more questions we need to start asking. And so the idea is just to try and gather information about where the firearms are located, how many, what kind, when was the last time folks have seen the firearms, so that we can then take it to law enforcement and prosecutors to sort of determine what's the next step. Is it safe to ask for voluntary compliance, have law enforcement, when they're serving the order, with specific information, say at the time of service, with a warm, what do you call it? A warm approach. A warm approach. Ask for immediate compliance. Here's your order to surrender weapons. We know that you have one in the ottoman and also in the nightstand. Can you please allow us to go and collect those now? We'll do that for you. Detective Stankovich will talk more about that later, but there's a bunch of questions here that are really specific to trying to gather as much information to give law enforcement the ability to ask for voluntary compliance. There's also questions in here that are specific to trying to gather information for prosecutors and law enforcement in case there's not compliance and in case we're evaluating whether or not there's an opportunity for a search warrant. And so there's some questions in there that are specific to that. And then there's advocacy questions. Are there other cases going on? Have you made police reports? Safety planning information about 1501, the Lion Tribe, so trying to get people registered so that they'll be notified if their user purchases a firearm after they've been prohibited. And so that's kind of what this worksheet is, and I'll just say that it can easily be used and redeveloped for each particular jurisdiction's needs.
And what are some of the biggest concerns that petitioners share with you during this process?
So a lot, as every advocate in the room knows, petitioners are concerned when any victim is concerned for the most part, when their abuser has access to firearms. We all know the statistics about the risk. We all know the statistics about the likelihood of homicide, especially during the time when somebody's separated from an abuser. But the victims and survivors know it, and they know it regardless of what the statistics say, because it's often been a tool of coercion and fear and intimidation in their home. So there's sometimes specific concerns about, like, how is this process going to work? How are you going to collect the firearms? Other times, petitioners or victims are really more concerned about other things because of sort of that hierarchy of needs. There's more immediate concerns. And that's why I think it's so important for advocates to be involved so we can identify if a survivor's like, I can't even think about the firearms quite yet because I need to get my kids back, or I just got this eviction notice, or I need to know when he's getting out of jail, then an experienced advocate can really kind of help work on those immediate needs so that then the firearms and the safety of the entire community can be addressed after the immediate needs are addressed. So those are some of the concerns. Other times, it's really specific concerns about when a protection order is going to be served and how that looks. So I've had survivors tell me, please communicate with law enforcement. Do not serve this next Thursday when he has the kids after school. Because if he doesn't give up the gun at that particular point, they walk away and he's alone with the kids. Or we've coordinated really specifically to follow a survivor safety plan and arranging service just right, so it fits specifically with a survivor safety plan. So those are some of the concerns. And I think just going back to almost everybody I talk to is really just concerned about the immediacy because they know the risk is high when their abuser is about to be served with an order to surrender weapons, or in criminal cases, the risk is high during that arraignment process and the initial arrest.
So your unit has been doing this work for over a year now. What are some of the key lessons that you've learned that you can share with the room?
Yeah, well, one of the first things that happened in our unit is that a bunch of folks started going to a civil firearms review calendar where protection order cases with an order to surrender a weapon, the respondent was required to come back and say to the court whether or not he or she has complied by surrendering their firearms. And a lot of people lied, they just walked in and there was no follow-up. And then so they started to do some follow-up, and on one of the cases they just made a couple phone calls. Boom, there's immediate information about firearms. He's lied to the court, he's in violation, they're able to get a search warrant, they go in and collect, I don't know how many, 11 guns on the first one. And so we were very energized by that. Okay, so what we need to do is we need to go in and look at all these cases on the firearm review calendar and gather information and get a bunch of search warrants. At least that's kind of initially how we were like, oh, let's work it this way. And what we learned is that, first of all, that scenario does not get replicated very often. By the time people get to the firearm review calendar, oftentimes firearm information is quite stale, too old to get a search warrant, and we're having a hard time getting a hold of people. The people who are actually the most dangerous aren't the ones showing up in court on the firearm review calendar. And so the biggest lesson we learned is that we need to work on cases at the beginning, immediately. How do we get this information up front rather than retroactively? Because that's completely ignoring the risk and the statistics on timing of when abusers are at the highest risk to victims. So we went back and we tried to work with the judicial administration to get a list of all the cases where orders to surrender weapons were filed. So now we get an email every day that tells us which cases. We can go in and try and research that immediately, gather the information right away, and send it to law enforcement right away, and then have our prosecutors at the table to staff cases when somebody doesn't comply, or if they're already a prohibited possessor and the survivor is telling us information about a firearm in the home.
And tell me a little bit about how advocacy relates to your work.
Yeah, I kind of already touched on this, but I think that safety planning is so important. We know these are the highest risk cases, and we know that people are very particularly vulnerable when they're separating from an abuser and their abuser has firearms. So we've actually worked to try and give every person, every time, firearm-specific safety planning information. And I have the link to that firearm-specific safety plan if anybody wants it. You can just email me. But it's really like talking with people about what to do if this, if the guns are still present in the home, or if everybody knows that people can still find ways to get guns even if they aren't allowed to possess them. And so really working with survivors on a very specific safety plan around that. And I think also we work on trauma-informed interviewing, so rather than just asking a litany of questions, we're recognizing some of the patterns, we're letting people tell their story, we're trying to approach it from an advocacy angle, offering in the midst of it domestic violence education and safety planning as people share information with us. I touched on the confidentiality piece and why that's so important. And then I think finally, I think when we're at our review, when we review cases together, I think advocates have a particular way of knowing when to push and to identify and triage cases that are the highest risk. I think advocates know very well how to humanize a survivor and their particular situation so that folks in the system can respond in a way that's appropriate for what her position is. For example, we were just talking about a case the other day. It was a criminal case, and there was an arrest, and the abuser was there was no contact order issued, and so he was not allowed back at the home. And the criminal victim advocate reached out to us and said, "Hey, there's a bunch of guns in the home. Can you guys do something? Can you figure out what to do with all these guns that are in the home with the victim because she doesn't feel safe?" And so we talked about it, and there was sort of, it's going to be a huge project for somebody to go out and get those guns. Can't she just turn them in herself? And so an advocate, we were able to say, hey, she has a 4-month-old baby, and she doesn't know if any of these 20-something weapons are loaded or unloaded, and she's like carrying this baby in this soft pack, and she's not going to turn them in herself. She's not going to walk around the house and collect them all. But I think kind of the idea of like humanizing the victim, knowing what cases to push, and then just really coming back and talking about it as an interdisciplinary team to show that we may not always, we come from very different perspectives, and we may not always agree on the best approach to intervene in a situation, just like a criminal advocate and a criminal prosecutor sit down and have that same kind of relationship. But everybody's perspective is represented. There's been cases where we haven't pushed forward on certain things because the victim said it wasn't safe for her or didn't want to be identified as a witness. And there's cases where we've had we've had a sense that a victim didn't really necessarily want to see us do certain things, but ultimately it was determined that the safety of the community and the safety of this victim, things needed to be done. And so just having that interdisciplinary team to have the conversation and have the victim's wishes represented at the table, I think is really important.
Thanks, Theresa. So you mentioned that folks can reach out to you. This seems like a good time to tell folks there are business cards in the back where you picked up your name tag, which has the unit's contact information on it. We'll also be following up after today, sharing presentations and information. So you should have all of that at your disposal. I want to move on to Joe. What does your team do in advance of removal to make sure that it is done as safely as possible?
Okay, we'll do kind of what we do with all the orders. I mean, we'll check the respondent in WASIC, NCIC, see if they have any outstanding warrants, see if any hazard flags exist, whether that be a mental health caution or a threat to law enforcement. There's a flag for that. Also research firearm possession, see if they have any on their record, firearms purchase history, and see if they have a concealed pistol license. From there, we'll also do a risk assessment matrix, and which is a whole page of different criteria. If any of those are triggered, we'll kind of conduct the service in a different way. We'll also form an operations plan, how to help to serve the order, designate contact cover, which roles each of us are going to have. We always go out in two teams, or correction, a team of two. Depending on the background information that we get, we may go out as a whole, all five of us will go out. One of the things we definitely want to have with us is the CPL and purchase history in our hands, so that way we're going to know that information ahead of time in case the respondent denies having any firearms. Yeah, I guess that's about it for that.
Sorry, I just want to add in one thing, is that sometimes when we run CPL and purchase history, there are delay in those information entered into the Department of Licensing. So not all the information that we get on the firearms are going to appear on the purchase history. So we rely on petitioner a lot to give us those information as to what type of gun, how many there are, and what they are, what they look like, what color. We get all those specifics, and then we contact the law enforcement agency and call them and give them a heads up. And I have to say that, last year when our unit first started and I call and give those information to any particular South County Police Department, they go like, who are you and why are you calling me? Nowadays, they are so appreciative of those information being given to them ahead of time, because mainly is that with firearm and domestic violence, officer safety always comes first as well in my mind when an officer is going out to serve those protection orders, because that's also a very dangerous time when a respondent has to give up their firearms. So I just want to share that Department of Licensing has about 600,000 purchase history that is not being entered yet, and then I think starting July they have to enter the long guns as well into the system, and I think that's a backlog of 170,000. So those informations are not on purchase history, so we rely on petitioner survivors and community advocates or felony advocates who are working closely with the victims to get those information about what types of guns the respondent has.
Just real quickly, when we gather that information, we have two law enforcement agencies where we really partner closely with, who have dedicated detectives like Detective Stankovich, who we can pass that information on to, and they can really take that with them on service. But there's lots of law enforcement agencies that don't have a particularly assigned detective just for firearms, serving, protection orders, and recovery. And I just to the advocates and folks out there who are kind of going to start working on this, the records people and the folks in the civil division of law enforcement, Those folks who answer the phone are absolutely the key to trying to connect this information and give it out to patrol or whoever's serving these orders. The more relationships that we've been able to build with records staff or civil staff, if it's the sheriff's office, the more effective we're able to see firearms being removed, even if it wasn't particularly part of the protocol with that law enforcement agency. And so I think those are the people with the power, are the folks in the records, and they're able to really, when we can share with them, these are the risks, this is the stuff we're looking at with this particular case, can you potentially ask them to treat it in this particular way? Things happen that way.
Yeah, I just might add. Yeah, in addition to the firearms worksheet, sometimes some of these orders will be accompanied by an interview with the petitioner about the firearms that they're reporting that the respondent may have. I had one order not too long ago where the petitioner was actually gave a detailed description of multiple firearms that were stashed in the house. Like there was a long gun in the kitchen pantry, there was one underneath the bed. There was a handgun or two in the ottoman by the lazy boy. I mean, it was completely detailed. So having that kind of information was pretty extraordinary. So we definitely appreciate having that.
Can you talk a little bit about the higher risk service and removal situations you've been part of?
Oh yeah. So with these type of orders, as I mentioned earlier, we'll do a risk assessment matrix. If any of these criteria are triggered, we'll bring out the SWAT team to come out and assist us in the service. Ironically, they're usually standing behind me while I knock on the door, and I never really understood that, but they're just kind of silent, muscle, if you will. But yeah, so our risk assessment matrix, I brought a list of it. I won't read all of them, but if some of these are triggered, what we're going to do is we're going to call SWAT and actually screen this type of service with the SWAT team, and they actually make the final determination on whether or not they're going to go out with us. But some of the criteria includes it's a large multi-story building that's going to make a difference. If any people do have warrants, there's going to be more than 4 subjects believed to be at the location. If any of them have some gang affiliations, if we get any kind of indication that it may be a fortified residence, we'll use that as a criteria to kind of screen it as well. In addition to just the criminal history of the respondent, if they have any indication of homicide, kidnapping, rape, or robbery, arrests or convictions, we'll look at that, and those could also be triggered for that. Answer number 3, I think, with that.
What advice do you want to give law enforcement officers as they are looking at different ways to approach this issue?
I think it's helpful to have a designated group of officers, even if it's only 2 officers. They're kind of familiar with these type of orders, or really with any kind of orders that are being served. A lot of these we found to be kind of confusing at times, just the service of court orders. There's a lot of different parts of it. A lot of times respondents are going to ask us questions about the orders. So prior to getting into this unit, I didn't really know a whole lot about protection orders. We would get them occasionally at patrol. They'll be dropped off at the precinct, started in roll calls like, here, go serve this order. I'm looking at it thinking, I don't even know what this is, really. It says protection on it, so I hand them the packet and tell them they've been served. When it comes to fill out the return of service, I remember checking, I don't know, it's a protection order. I mean, it turned out a lot of these were just temporary protection orders with notice of hearing, and with a petition attached to it. I had no idea that's what that was. So we didn't really get any kind of training on anything like that. So now I'm kind of being in the unit, becoming familiar with the whole process of protection orders, what exactly they are, the different parts of it, being able to answer questions that the respondent may have about it. is definitely helpful. So having a dedicated, group of officers to kind of handle these types of orders that could be complicated is definitely helpful. But also having a relationship with the court people. I mean, without these people up here, we would not be successful. I mean, we're always calling over or having meetings with them about different court orders that we need to get served. Sometimes these court orders are missing pieces of them, so to have a direct link to be able to call over and say, hey, look, I'm actually missing the petition on this order. Can you please see if you can find it and send it over? So having that kind of relationship with the court, I think, is definitely key. Something else, having the safety matrix. I mean, having some kind of standard where you're going to say, okay, wait a minute, we have these criteria that are met. We want to keep, safe when doing this. Obviously, safety is paramount. This is going to now trigger, the SWAT team or maybe some kind of tactical squad that may go out with you to assist with these orders. But if you just kind of say, well, maybe we should, maybe we shouldn't, we don't really know. We don't really have a standard on that. You're just kind of winging it. So to have something official on paper that'll trigger those different units to assist you, I think, is key. Last thing, I mean, the soft approach. I'm pretty low key when I do this. I never like to tell people, hey, you've been served. Nobody likes to hear that. Nobody wants to get served. Nobody wants to give up their guns. So once you show up, I mean, usually the respondent's already kind of jacked up. I mean, their adrenaline's already going naturally, kind of given nature. So to go in there, a little softer approach. We all kind of have a modified uniform. We're not in the Class A or Class B uniform. We have a black polo that we'll wear, and we don't necessarily have all of our tactical gear going in there, heavy. In our cars or unmarked cars, we have a Ford Fusion unmarked. We do have a Ford Explorer that's unmarked. But going in there like that, I think, is a little bit more helpful for us. It is good that we are identified as law enforcement. That saves us from having to explain that and having to prove that. But to go in there a little softer approach like that is helpful. I keep everything really low key. I usually say, hey, I got some papers that the court wanted me to deliver out to you. I never want to say, hey, this is a court order. Because I don't want to get that kind of resistance. And I just kind of explain it to them. And I always like to explain up front, hey, this is just a civil order. We're not here to arrest you. We're not here to, really take things to another level. Hey, we just got this a civil order. It says something, you got to abide by these things here. Something else about a firearm, maybe do you have anything like I just try to keep it really low key. It just helps, It's always been my kind of policing style anyway. Bad cop never really worked for me. I just kind of be the good cop and just keep it kind of low. I like to de-escalate before it even escalates. So that's probably what really adds to our success.
So we have a video for folks. This would be a great time to share your index cards with Logan if you have questions. Is your safety matrix something that you would be prepared to share with this group?
Sure. Yeah. I was just already reading off a few of those, but.
But after today's
if anybody wants to copy this, I'm happy to make a copy or email it, whatever you guys like.
Perfect. Hi, Divina. What types of orders do you look at?
A lot, all different kinds. I get most of my calls from law enforcement agencies, typically the records department, either the service or data entry. For some law enforcement, they have one of each. It's not just one place. They'll be missing a page. The fax didn't come through. And I get these from on Superior Court orders, District Court orders, Muni Court orders, and I've even gotten tribal orders that needed further clarification and information on.
We have some questions related to tribal orders, if you want to talk more about that now.
So I'm learning as we go along here. Of course, course, they've got their own jurisdictions and they have their own rules. One particular order, I had a law enforcement agency contact me, and the tribal order for protection, it was kind of like a one-pager, had everything written on it, and it was protection, anti-harassment, no weapons. It was kind of just, you know, all these little things. Nothing was really formally put on there, no real RCWs or tribal laws written on it. And the cops were like, well, what are we supposed to do with this? So I kind of had to go back to the tribal court, talk to their administrator, and say, okay, I kind of need some background on how your orders work, how do you enforce them amongst your, you know, your own tribe and your jurisdictional area. And she provided me with some background information, some of their court rules, so to speak. And so I passed that along to law enforcement, and they actually attached that to the order so that when they entered it and whoever accessed that order, they would see what the tribal court laws were in regards to that and their authority to actually issue those in their jurisdiction. But there's a lot of tribal laws I'm not aware of yet. I'm still learning and hoping to learn more about.
What are some of the biggest problems that law enforcement is experiencing?
I think the biggest one is they want the law enforcement information sheet, the LEIS, both for service and data. They both need it. They need to know who's protected, so they can put that into the WASIC. Who's the respondent? Where does he or she live? If there's any minors that are supposed to be listed on the order, they need them on the LEIS so that they can also enter those. And so I get calls every day or emails every day saying, the LEIS is not attached. What can you do for me? If it's a case that our protection order program has worked with the petitioner with, sometimes they'll have a copy in our internal management system. I can access it, send it right to them electronically. Most law enforcement agencies accept my emails and they get the information instantaneously. If not, we do a little bit of background. I'm sitting there reading the petition. I try to figure out where they now live, because sometimes the address in JABS, JIS, AOC, DOL, sometimes that's not the current address. So I try to get as much information as possible, and we create a dummy LEIS just so that we can put something into the system so that there isn't any holes in the WASIC, or, you know, a lot of times the order will be sitting in the problem box. Well, that's not going to do anything for that officer who's going out there on a call. He's saying, well, she's got a copy, but nothing's officially in our system. So one of the things I try to do is give them what they can, or what I can, so that that order gets online. And if we have to correct the address later, we can do that. Not a problem.
What would you say are the top 2 issues you deal with? Is that one of them?
Yes.
What is the other one?
Validation, and I think that covers a lot of things. The cops sometimes, or records units, will call me and they want to know, this order says it expired, you know, last year, it's still in our system, what happened? Or it'll say, they'll call me up and say, it doesn't expire till next year, but the respondent's on scene with the cop and he's got a dismissal or a recall order. And so sometimes it's like an immediate issue that they need fixed in the, you know, in the heat of the moment. And so then I'll be looking up court records, trying to figure out, is there a new order? Was there a replacement order? Was jurisdiction transferred to another venue? Dismissals, recalls, denied petitions. So I'm trying to find all that for them. Sometimes they're even saying, well, he says he has his gun rights back. And so I'm having to look through some records, and the ones that I can access, I try to get them as much as I can immediately.
What are all of the organizations or agencies that you support in this role?
My job is kind of constantly evolving. At one point, I was supposed to help with flawed orders and ERPOs. Flawed orders seems to have taken up a majority of my day, and it was, you know, primarily KCSO, King County Sheriff's Office, Seattle Police Department. But now I get calls from everyone, Des Moines, Tukwila. I've gotten calls from Pierce County Sheriffs, Snohomish County, Clallam County. I mean, I get calls from just about anyone who's heard of who I am or our unit, and they're like, we have an order, can you explain it? Or we have an order, is this still good? Do you have any more information on this? Or what's your guys' reasoning behind this order? You know, it could be a hodgepodge of questions, but I try to work with anyone who either emails or calls me for information.
Is it true that your job title is problem solver?
Yes.
Just wanted to confirm that. Thank you. I want to move on to Kim now. Kim, tell me about the compliance review calendar.
So the compliance review calendar happens in our court every Wednesday, and it is staffed by a prosecutor that appears before the court, and we are appearing on the civil side. So this is a very different role for us. It took us some strides to get there. We, as Chris and David said, we initially showed up in the back of the courtroom and started watching. Then the court became familiar that we were attending the hearing for, I think, weeks and weeks after that, and eventually made our way into appearing on the record. And something that's really kind of unique about that is we're appearing under a general order. So our Superior Court, our head Superior Court judge, and my office and the City Attorney's office, they all came together to create a general order. So we're appearing as a friend of the court to assist the court. So we appear both on the extreme risk protection order side and then also on the firearms surrender calendar. So that calendar, once again, is to make sure that folks who are showing up are in compliance with what the court's order is. So that's the very basics of what it is.
Is it required by statute?
It is not currently, at the time this was created, it's not required by statute. So Superior Court did a good job initially after the legislation passed in 2014. Sometime later, Superior Court judges created it in King County on their own. It just was the problem was that nobody was watching them to ensure compliance. So having a prosecutor there really does help. We triage or evaluate cases based on what Theresa and others, Lorinda, were saying, firearm negative and firearm positive. And I would really stress you all, if you're starting a program, we initially looked at everything and it was really overwhelming. So you have to pare down the work. And so we definitely focus on the firearm positive cases. And then within those, even when we're triaging, of course, we're looking at lethality, the highest risk ones, and the most time sensitive.
We had a question related to the gun positive, gun negative. Can you say what the ratio is between the two, as well as how many gun positive cases there were in 2018?
Okay. So we have a slide. I don't know if we can pull it up, but I can tell you. So in 2018, our unit reviewed, or courts issued 1,140 full domestic violence protection orders, and out of those, an order to surrender weapons was issued 1,105 times, so almost all of them. And out of those cases, it is number, yes. So as you can see, out of those, there are about half that were negative and a little more that were positive. So still a big number of cases.
What are some of the challenges that you've encountered as a prosecutor on the compliance review calendar?
I think we're doing a better job with law enforcement's help on the folks that are not in the system yet, so new to the criminal justice system. The folks that are already prohibited, we're having the same issues we would on the criminal side. We're having a harder time getting guns from felons already, mainly because we're having to still evaluate, is the information we have about firearms specific and recent enough to get a search warrant. And I can tell you our unit has tested those grounds a little bit, more so than anywhere else in our office. We have specific firearm templates, both for extreme risk protection order, search warrants, and then also for our work on orders to surrender weapons. And those were created by our special ops deputies that specialize in warrants. And so we did include a little bit of domestic violence language in them, meaning we're trying to distinguish between a crime gun, like in a gang case or a drug case, that's going to be moving around hand to hand. We put in a little bit of language to suggest that these should be looked at differently, that victims who have lived with respondents who have specific firearm knowledge, who know, like Theresa said, that the gun is always kept in the nightstand drawer. You know, that is different information than a crime gun. So we put in a little bit of that, and we're kind of testing that out, but we've struggled on the search warrant side. That's still an ongoing process.
Can we be sure everyone knows what a crime gun is?
Well, I just mean, a lot of case law in Washington is around drug cases, and forever ago I prosecuted those when we had a drug unit. And I just mean there's a distinction between somebody who's using a gun in a gang context or a drug context versus somebody who's holding on to it as a family heirloom, or, because guns are very valuable too often, right? So they're passed down generation to generation. So that's the distinction that I make.
What types of cases are you paying attention to now that maybe you weren't paying attention to before?
I think we're always looking at lethality, so I wouldn't say that. I would say we had to be more creative. So the case where Chris, David, and I sat in the back of the courtroom and the guy came in with the baby, he was actually ex-law enforcement from another state. We didn't end up getting a search warrant, and we did charge him with perjury. And so that was one of the few times in many, many years that our office has charged perjury. I think I had 3 or 4 cases last year with perjury being charged, and they all resolved. I can't remember all of them, but we definitely had perjury convictions for the first time. So we're saying you're coming to court, you're standing before the court, either you're being sworn in by the judge under oath to tell the truth, they'll say they don't have any firearms, or even better, they're signing the declaration of non-surrender saying they don't have firearms, and then we are able to confirm up that in fact they were in possession of firearms, usually by a search warrant. It could come in other means, but almost all of them have been that way. So we're going to hold you responsible if you lie to the court, and we can prove it.
Have you had to obtain any search warrants on these cases?
Yes, we have done, I would say probably not a ton. I probably did 10 or so last year. I've done more at about the same amount, maybe 8 or 9 on the ERPO side. I've had better luck on the ERPO side. I think we've gotten guns in every case. And I did one last night that's pending this morning on a criminal case. So that's something else that we do. We cross over with, we're still part of the criminal division. So we coordinate with our deputies that are handling felony domestic violence. We had one come in with a bunch of guns in the home. So I reviewed that search warrant late last night. And if we can, we're gonna also include for the court any order to surrender weapons language. We have included that if they fail to surrender, we're putting in the simple misdemeanor, and I know that law enforcement's not excited about that, but we put in as many crimes, obviously, that we have probable cause to believe he's committed. So we're throwing in there the protection order, specific statutes, same with the ERPO violations into the search warrant.
Seeing as we are here in Pierce County, we have 2 questions about how you work with military protection orders and how you kind of get your work done within the constraints of the military program. You want to take that, Ken?
Sure, just a little bit. I mean, I can tell you that about 2 years ago, my colleagues that runs our domestic violence unit at Kent, we came down, made a connection with JBLM because we have one of their former advocates that's now a domestic violence advocate. So we've been going down to JBLM at probably about just once a year, but meeting with their local police department and their JAG staff, attorneys that are there, and trying to share information. Because we quickly realized that although we may not have a huge military presence in Seattle, we definitely have some folks that live in South King County that are active military. Or we have folks that are being arrested for domestic violence at a concert at a hotel in Seattle, and they're active military. So we established some connections there just to share information. We also quickly realized that we have, there's a connection. We've had many cases with former military defendants and respondents, some with extensive amounts of firearms. And we had some questions about how to verify if some of these individuals had military criminal history. So we kind of created some of those inroads to be able to verify, did they get honorably discharged from the military, right? Because we know if they're dishonorably discharged from the military, that's a federal crime. So I'm going to refer that to my federal counterparts. We're going to establish that connection. And so I think it's a really important issue. And I know that I don't know if anybody is here from JBLM, but they were wonderful and great partners in wanting to share the work that we're doing.
I have a question for Theresa, and I'm going to read it because it's long. Restrained parties can't be arrested for violating a PO until served with it, and return hearings are continued if they're not served quickly enough. Does all this information gathering you do before sending an order to law enforcement for service end up delaying service? And if not, how do you prevent that?
Yes and no. So actually, I think oftentimes we're finding that the information gathered makes service happen quicker, because rather than law enforcement just getting a straight LEIS, which may not have very much information about how to serve the respondent, they're getting much more information from us after we've had an opportunity to speak with the victim. His work schedule is this, but he has Thursday off and his car looks like this, so if you see it in the driveway, or whatever, he's at his mom's house from 10 to 2. So giving the information that's really specific can actually help. And so many people don't have the right information in either the law enforcement system or on the LEIS, and so when people have, the cases come across our desk when there's firearms issues, but we're doing a lot of work, Lorinda and I and my job share partner Sabbath, to just ferret out like how to get somebody served. And so there's a lot of problem solving on that end, and so we're, I think, in some respects, effectuating service faster. There are cases where it delays for safety reasons, so maybe it's a case that the risk matrix says SWAT needs to be involved. Maybe there's a different approach, be it if for safety reasons has to happen at work rather than at home. Maybe it needs to be worked up for a search warrant first. And so I'd say that on the whole, it's probably making it faster, but certainly there are times where it's delayed. Twice we've definitely delayed it on purpose at the victim's request. So like I said, the one where she was like, don't serve her right away because my kids are with them. And that was at the petitioner's request. Another time, petitioner said that he had a whole plan that was really specific, and he had done all this safety planning because it was an extremely highly lethal case. And we got it, and this was sort of a ethical issue for us advocates, because he said, I want this to continue. I don't want him to be served until after I get the keys to my condo, because I've got this whole plan to get him served then. When I have a safe place to live, there was all this coordination with his friends and family. He had boxes hidden. He had people flying in to help him move, and he was like, if you serve it before that, he's going to shoot himself. And so you need to wait. And so we were sitting on this information saying to ourselves, okay, we know this guy has made threats of suicide. We know he said if the victim leaves him, he'll kill him. He's highly monitored with video cameras all over the home. All of our phones conversations are happening in 3-minute increments while he's in the bathroom, not being monitored. And it's a highly risky situation. At any point, this could hit the fan. But he's asking us, please wait, because I've worked so hard on this plan. And so we had to sit with that and wonder, what's going to be, what if something happens and we had this information and didn't act quickly? Or do we try to really honor this victim's wishes, who's worked so hard on this safety plan, and come alongside him? It was hard, but we were able to come alongside him, coordinate with 2 different jurisdictions to make sure the respondent was served at the exact same time that the video cameras were turned off, and the petitioner told the abuser, oh, Comcast is down, and all of this happened simultaneously on a DV protection order because law enforcement recognized that this was risk and was able to kind of connect with advocates in our unit on it. And so it was really effective. They were able to retrieve 2 firearms at the scene, and there was no future terrible thing that happened, which we were all worried about. But yeah, so it's yes and no, sorry.
So those are good examples of the order being delayed. What happens if during the course of an interview you learn that there is no safety plan? Like, what are your next steps on that?
Yeah, well, and that's the vast majority of people we talk to don't have safety plans. Many people are just walking in asking for a protection order from the courts and kind of just starting this process after finally coming to a place where they're ready to ask for protection, but not necessarily have had a chance to connect with community advocates or maybe haven't had intersections with the criminal justice system where they've been assigned a criminal advocate. And so we're doing a lot of that safety planning with people. We're safety planning every person, every time, because we know that safety planning is statistically going to help people stay safe. And so I mentioned that firearm-specific safety plan. We talk with people about this. It's actually a tool that's created from the National Coalition Against Domestic Violence, and it's online. It's sort of embedded deep in a blog post. So if you Google domestic violence firearms safety plan, it'll pop up, but I have the link to it as well. And it really goes into the details, like how to familiarize yourself with your partner's firearms when you're in the situation and you're living there, how to plan if a gun is drawn, to position your body so that if shots are fired, it doesn't continue on to children, how to run between cover, between shots being fired, how to handle a wound in the midst of it. And so these are things that aren't easy or fun to talk about with survivors who are in a position where they're facing a partner who has firearms and they're trying to keep themselves safe. But these are life-saving tools, I believe. So we work every time. And there's a lot of cases, which I'm sure is abundantly obvious to those who are in the system, but we can't do anything. We gather all the information, and there's just not a path to do anything. And those are the cases where it's so important to work on safety planning with survivors, because we know that their partner is always going to have access to guns, and they are still in a situation where they have to be in fear of that, and they're interacting with them and exchanging children, and so having that specific safety planning tool is really important for those folks.
Do you want to talk about the number of firearms recovered in 2018?
Well, we've been talking about what we were doing, so we just wanted to share that we were able to, the unit was able to, with of course the assistance of law enforcement, recover 592 firearms. And I believe the breakdown is 200 something from ERPOs, and then the rest from order to surrender weapons cases. And so that is a significant increase compared to the prior year, and I should know what it was the prior year, but I think it was very dismal. So it's a real increase in the number of firearms that are, or would not have been, I believe, surrendered had it not been for some enforcement unit like this. So I just want to share that.
We have time for more audience questions, but before we do, I'm wondering if there were any points you meant to hit during your time that you've now thought of.
Well, I would just give suggestions to law enforcement and prosecutors that are trying, that may not have a unit, but want to try to do some of their own enforcement, is to be creative a little bit. We've looked at fish and wildlife records. I think David and Chris might have mentioned that, but for a respondent that had registered for a hunting tag for a turkey, I think it was a turkey tag, and had, I'm not a hunter, I'm not sure, anybody identified the specific firearm or weapon that he was going to use. So we were able to coordinate with them to get some of their records to be able to show when he showed up in court and tried to deny it, that at least he has knowledge. And that was very, 6 months ago, he had at least applied to the Fish and Wildlife for a record. We have also used social media, of course, to come to the court at these compliance hearings or at a bail hearing in the criminal side, show the court photos of firearms with the respondent or defendant in what looks like a gun, holding a gun, or in possession of firearms. So we just really tried to gather as much information as we can. We also have reached out to other states to confirm if somebody has their version of a concealed pistol license. In California, if you ever have a respondent from California, they have a really great program that very active. Is it through the Attorney General down there? Department of Justice, but really helpful. They executed, I think, 2 search warrants based on cases up here, based on our orders to surrender weapons. So that's something, So I would just say to keep the efforts going and don't feel like you have to reinvent the wheel, that you can always reach out to us for suggestions. And if you're doing something, we'd love to hear about it too.
I just wanted to just touch a little bit again on the delay of entry. In King County, our court systems are still faxing, mailing. the official copy to the law enforcement agency that needs it. So in terms of delay, it's not so much a delay that they're not going to ever get that order or that it's being held. A lot of times our advocates are already on the phone talking to the petitioners. They've already got background information so they can actually call the law enforcement agency and say, hey, I spoke with the petitioner. I know you just got this order. We wanted to talk about service on it and maybe a better way to do the service. So delay may be a kind of a sticky word to be using, and then it's still getting into data and it's still getting to the law enforcement agency. There just might be just a timing issue with the actual patrol officer delivering the orders.
We did the similar summit in Spokane, and some of the folks are here from that. And I just wanted to pass on two of the things that the speakers said there that was really specific to folks who are trying to set up this kind of program and are working through the logistics. One of the things Major Taft Harper from Maryland said, she talked about the importance of being relentless. And I think, and someone else had talked about being a loving agitator. That like these things are not easy to set up, and yet we know the risks, and it's so important to push forward and do the small tweaks that we can, and really just talking about just trying to find creative ways to do it in your jurisdiction. And surely not everybody is able to have an entire unit dedicated to this, but many people in their individual roles can make little tweaks in their work to change the way, change the outcome, and frankly prevent homicides. And so we're so happy to be resources to anybody who's kind of looking at reframing some of the work they do to try and just find the one piece that can be tweaked. And we'll talk a little bit more about that this afternoon, I think, but I just wanted to give that encouragement and those words that I wrote down as I was sitting in Spokane, the importance of being relentless and being a loving agitator.
I'll just reiterate, you know, when you're serving the orders, you want to keep it calm, keep it cool. You know, it's always better to gain compliance than to have to go back afterwards and try to get a search warrant or work up a criminal case. So I always explain to them, you know, look, I really don't want you to get jammed up over this. You know, let's do it this way. Have them sign the Declaration of Non-Surrender, or actually have them turn in the firearm. That's why we're really there. And it's just so much easier to do it that way than the hard way.
Yeah, I just want to echo what Theresa was saying, you know, be relentless and doing follow-ups, because those are very, very important. You know, for example, especially follow-up, I think, too, with respondent, quote-unquote, in compliance. I was working on a case where the respondent did turn in a firearm to 5 police department, and he actually got a receipt and filed it with court and say that he turned it in. But then when it comes to the firearm review hearing, the petitioner with the her attorney was asking, wait a minute, what gun did he turn in? So I was able to contact 5 police department, have the evidence room, took a picture of what he turned in, and compare to the picture that she has of him holding a gun. It's 2 totally different guns. So right now that case is actually in Court of Appeal because he was found not in compliance because of that discrepancy. And so just wanted to share that with you, that sometimes information that we get, and then sometimes we think that respondents in compliance is quote-unquote compliance until actually we can verify those information. And just wanted to, you know, sometimes those compliant calendars, respondents showing up, they sometimes testify. So the judge in the courtroom is also making that determination. So we have some distinction about that as well, or sometimes they said that they come in as lost or stolen. And so a lot of the follow-up and in contact with the petitioner and with the victims is very important. So, you know, in interdisciplinary team approach, I think that's the key, right? To work with everyone sitting on the table and sharing information. So I just want to share that.
So we have just a few minutes to spare if there are any lingering questions before lunch. Yes.
I love it. I love your whole approach. how it is real criminal justice reform, and it's looking out after prevention of homicide for potential victims, but also reducing the perpetrators that are going to get incarcerated and fill the jails more. So I think something's going great. The one question that lingers for me is, even though it does sound like you just have made so much headway, and in the end, do you have situations where the person, the respondent, is just not showing up for those hearings, and they schedule another hearing and they're just not showing up? Has your unit and the courts developed what is going to happen? Are they going to get held in contempt of that? Are they going to get picked up? And what happens? Has anything played all the way out yet where there's going to be something?
Who wants to take that one? Kim does.
So we've had a real struggle with that, to be honest. And so we have looked if there's a way to charge them criminally. So meaning if we have a cooperating victim, there's recent domestic violence, can we develop a criminal case at all to try to kind of force compliance? We are in ongoing discussions. We've tried different things. We've tried to file the charge of failure to comply, which is a simple misdemeanor, which didn't really pan out. And so our current ongoing discussions are contempt. So to ask either the court to initiate civil contempt or to have the private attorneys that are coming in from legal aid that are representing our victims to ask the court for civil contempt. We've also actively explored criminal contempt, similar to how our family support division does it on child support cases. So we are currently modifying, they have a specific statute that allows it, but we're adopting that to create forms for criminal contempt and going through that process right now. And it's been a long haul. I think that's the really hard and frustrating part for victims, that if we don't have enough legally, the information's not fresh enough to do a search warrant, sometimes we are a little bit stuck. And that's just the reality of it. But at least we have discussed the options with senior attorneys and advocates and everyone to explore everything that we possibly can do. I mean, we'll pull jail calls just like anything if they're booked for something, to try to verify. We've had good luck on a couple cases with them talking about, just defendants specifically talking about guns in the location. So we're doing everything that we know to do, but we're not quite there on the contempt part yet. But I think that's the next phase for those that just blow it off.
Any more questions? No. So to recap, relentless agitators when getting the order, easy breezy when serving the order.
Yeah.
Perfect. Well, thank you so much, panel. Really appreciate you sharing all of the insight as well as your offer to be a continued resource for the folks in this room. So thanks so much. So we are now going to break for lunch. If you request